Bamodi Bojang, Way Sankarango. Mansarin Kilinge, Birika Masumakunda, Bamodi Bojang, Way Sankarango. Munala Kilinge, Birika Masumakunda, Bamodi Bojang, Way Sankarango. Sangaranga ini urara ilodula le bamanda wala dinambe jamuna ba modu yebangu dinkende ada fale pa modu ida be hero lukono Gambia melie demokrasi murundi nanga Gambia kono Bojang Sangaranga ilo de la banco yela banco bondi mola hero media la hero mola hero media la hero
Traveling has never been this simple in the Gambia. Oh yes, you don't need to visit the GTSC depot just to get a ticket. Just download the Yona Wallet app today and enjoy hassle-free bookings. With Yona Wallet, you can buy your GTSC bus ticket right from your phone, anytime, anywhere. From Kanifing to Dakar, Dakar to Banjul, or upcountry routes like Kanifing to Basse and Basse to Banjul, Yona Wallet has you covered. No queues, no stress. Just safe, fast, and convenient ticketing at your fingertips. Choose comfort, choose convenience, choose GTSC with Yona Wallet. Yona Wallet, your money, your way. GTSC, moving the nation forward. For more information, please call 1124 or 221-1668.
Very eager to also understand, have a deep root of knowledge on this team. And I'm sure they are eager to learn a lot from you today. So on that regard, I would like to call on Dr. LAMIN Darboe, who is the guest speaker of our today's event, to come and give us his insight of this great team. Let us give this gentleman a round of applause. So, Mr. Darboe, you are highly welcome on the podium. Let's clap for him again, please.
Thank you very much. I extend my regards to Professor Fane and senior counsel, like he said, he's my senior counsel, Almami Fandintal, who was also a judge of the High Court of the Gambia. So I can call him my Lord Honorable Justice Fandintal, Almami Fandintal. I also extend my greetings and high regards to Bakari Nyambi Toure, Dr. Bakar Nyambi didn't tell you that he's from Gunjur. He's from Gunjur, and we all look up to him as one of the first highly educated people from that community. In fact, he was among the first people who ventured into the arena of Western education from Gunjur, because his father was a chief, and the children of chiefs got that opportunity. I also greet Mr. Brahman Dinjete, a colleague and a friend of Dr. Bakari Nyambi, and like they said, they are here on behalf of the former Vice President of the Republic of the Gambia. He also served as ambassador to the Republic of Senegal, and he came back home to serve as minister after his critical role in securing the intervention of the Republic of Senegal to reinstall the government of Sadauda, which was effectively overthrown by the Kukwe Rebellion in 1981. I know this because I was working at Radio Gambia at the time. So on behalf of Baby Darboe, we say thank you to Dr. Toure and Mr. Jait. I also extend my regards to Dr. Ensa Toure, an associate professor at the University of the Gambia. I extend my greetings to members of the UTG History Society. As a historian myself, and it is still my first academic love, I prefer history to law. I still read history. Not for exams. I'm past that stage, but yes, I'm very much interested in history. So why was I interested in history? Because I like to read, also follow current affairs, and the likes of Marcus Tullius Cicero. Cicero was, of course, a Roman statesman, a historian, a writer, a scholar, a philosopher. So he was Rome's answer to the great intellectuals of the era, mostly men and thinkers from the neighboring country of Greece. So one day his sister-in-law complained to him that she didn't like politics. Cicero was very annoyed by that, and he said, "What is not to like about politics? You might as well say you don't like life itself, for politics is history on the wings." History on the wings, he said, was what politics is about. Because what is political today will become historical tomorrow. For example, 1981, it was a great event in the historical development of the Gambia. 1994 as well, when Yahya Jammeh and his colleagues came and overthrew the government of the PPP under the leadership of Sadauda Kairaba Jawara, the first president of the Republic of the Gambia. So as a historian myself, I am in good company here. But one advice I have for you is don't read history for your exams, in readiness for exams. It's a great discipline. Yes, so don't study history to merely pass your exams, but to become an all-round intellectual. Because if you study history properly, you don't need to study English as a language. You don't need to study philosophy. You don't need to study politics. I call history the queen of the social sciences, so it incorporates all of those disciplines. Yes. Yeah, it offers you great opportunity to understand humanity, the human society, and to master language and be exceptionally placed to understand society and how politics and other developments happen in our society. So here we are told to discuss the draft constitution and in the context of the rule of law. So as a national document, the constitution of a democratic society, and this is not the Gambia alone, my senior counsel, Honorable Justice Almami Fandintal, said something about good government. So if you talk about constitutions, even dictatorships have constitutions. Sometimes very nice constitutions, very beautiful constitutions, but just on paper. And that is not what constitutionalism or constitution should be about. It should be about human rights, respect for individuals, all members of society. That is critical. If you don't have that as a foundation of your public life will probably fail. It won't take you anywhere unless, of course, you change course and do what you are supposed to do as a society. So as a national document, the constitution of a democratic society must settle public power in a manner that avoids concentrating authority in any one segment of a political system. In no small way, the 1997 Constitution of the Republic of the Gambia comprehensively failed this basic test. Yes, there are theoretical delineations, that is, theoretical separations between the executive, the National Assembly, and the judiciary. Between the traditional, these are the traditional arms of a democratic polity. And the Constitution's self-serving claim of separating power, the reality is completely different. Not only are the legislative and the judicial branches of government accorded inferior status in the 1997 Constitution by making both ultimately answerable to the executive, critical independent agencies necessary to the proper functioning of a democratic society are all similarly degraded. Degraded in the sense that they are there, but they play no meaningful role in the public life of the Gambia. They are just there. In a nutshell, meaningful national power is concentrated in the presidency, in the most benign hands, in the most kind hands. Such concentration of public power can only erode the freedoms essential to creating and nurturing a truly democratic society. In addition, there are express contradictions between key constitutional provisions, as well as considerable fluff, things that need not be in the Constitution. Constitutions are framework documents. You can't give us a constitution that is 200 pages. You look at it straight away and you know that half of that constitution is not necessary. The provisions that are there should go into separate legislation to make it possible for the constitution to operate properly. But they should not be in the constitution. They are not constitutional provisions. The constitution is a framework document to be interpreted by the judiciary, not for you to interpret or to try to interpret everything in the Constitution for the judiciary. That is the organ of state mandated to interpret the laws of any country, but in our case here, the Gambia. Of course, the penchant for amending the Constitution, the 1997 Constitution was amended almost 58 times. The American Constitution, more than 230-something years old, was amended just 27 times in that entire period. Our 1997 Constitution was amended almost 58 times in a space of between, because most of those amendments were done between 1994 and 2001. So you are looking at 1997 and 2001. So you are looking at a very, very short space of time. So the Constitution effectively was just serving the interest of the executive, then in charge of the Gambia, the executive of His Excellency, President Jammeh. Yes, that is not the way you should approach the democratic life and the constitution of a republican country. So accepting that a polity with big institutions cannot ensure accountability under the best constitution, there is nevertheless a compelling need to retreat from the amalgamation of public power in one branch of government, and this by the supreme law of the Gambia. It was done by the Constitution itself, because its Constitution is not capable of self-implementation. It has to be implemented. So if you are the president and you don't like a provision of the Constitution, what do? You amend it. But that is your interest alone. It is not the interest of the Republic of the Gambia. Yes. So I argue for the sensible allocation of public power by the proper demarcation, that you create boundaries of constitutional authority between fully independent and internally self-governing branches of government. Yes. And those self-governing branches are the National Assembly, the judiciary, and of course, the all-powerful executive. Because in any setup, in fact, the reason why we have modern constitutions was because the executive cannot control itself. It just wants to control all the public power that is in a country. And that obviously would lead to dictatorship. And it is not in the interest of the country. It is in everything or every way just a monarchy. We call it limited republican government, but in actual fact, it's just a monarchical type of government. Yes. So, and I therefore, for me, I propose efficacious independent agencies that is useful and internally coherent, rationalized, shorter and more democratically robust constitution. The American Constitution can go into our 1997 Constitution maybe 20, 30 times. Yeah. And it is a complicated, sophisticated, highly developed society. So they don't pretend that the executive would have an ability to give us a constitution that can last. Once it is more than 200 pages, it becomes difficult for even the organ that should be advising the government, that is the Attorney General's chambers, to keep track of the contradictions within the document. It can only negatively affect the country. So if we look at the architecture of Gambia's legal regime, it exposes the dual anomaly of laws that are differently applied on the one hand, and laws that internally conflict, incoherent, schizophrenic even on the other. The same constitution would say the president can remove judges if as he pleases. Another section on the removal of judges would say you have to go through the National Assembly. You guess which provision His Excellency President Jammeh uses, the one that gives him the authority to call a judge and said you are fired. Sometimes with no letter, sometimes with a 2-line letter. And you are going home because you know what happens if you want to complain. Yeah. So, however, systemic incoherence of a legal regime in terms of conflicting provisions on the same issues present a more profound challenge to meaningful existence and survival of any nation that prides itself as a plural democracy anchored in the separation of power, which is very, very critical. Separation of power is an arm of the rule of law. In the hierarchy of law, it is common currency that the constitution of a nation sits at the apex. In the Gambia, that state of affairs is expressly enshrined in the actual text of the Constitution of the Gambia 1997. In Section 4, there is a supremacy statement there. It says that any law that conflicts with a provision of this Constitution is null and void as far as that conflict is concerned. But the Constitution, by deliberate design, concentrates power in the hands of the executive to the detriment of pluralism and accountability. It has a very labyrinthine structure. It's very difficult to follow all the provisions of the Constitution. So this guarantees conflict between provisions of the Constitution touching on the same matters, like, for example, the removal of judges. However viewed, this is a matter of great concern, but some observers would, of course, at the time would say, it doesn't matter. The systemic difficulties with the 1997 Constitution were plain to everybody. But there was nothing you can do about it as long as that dispensation remains in power. But now that dispensation was no more since 2017. And we are unable to get a constitution up to now, almost 9, 10 years, going into 10 years. We don't have a replacement constitution. So what happened? Yes, when somebody was running that machine, we were complaining. But when the current government came into power, it continued running that machine the way the former government was doing it because it works for you. So if you are not an accountable government, you don't want accountability, so you leave laws that are outdated, provisions of the Constitution that shouldn't be there, you leave them intact. Subsidiary legislation or statutory laws that are also detrimental to the state are left there. For example, today if you take the government of the Gambia to court, you cannot get an injunction against the government because there was a colonial law that prohibited that under the State Proceedings Act. You cannot get an injunction. But we got that law from the United Kingdom of Britain and Northern Ireland. That was where we got the law from. Now, when I was practicing immigration law in the UK, we can make applications to the High Court and remove Gambians on the plane to be deported to the Gambia from the plane back into the UK. Today, you cannot do that in the Gambia, and we got that law from the UK. UK is no longer using it, but we are hanging on to it as if our life depends on it. Yes, this is unaccountable government. It needs to stop. If you look at the Public Order Act, yes, every country needs public order. But the Public Order Act, as we inherited it in 1963, is too draconian. You know, a democratic country that fought for independence and remove the colonial leaders must not use the same laws against their own people. Yes, that is also backward. and you are not interested in the rule of law, you are just interested in protecting yourself. But you reach a point where nobody can protect you. You cannot even protect yourself. That is the reality of public life. It does happen from time to time. Even granting the plausibility, that is, of the contention that systemic constitutional reform was impossible to 2016, and it was impossible, yes, because the 1997 Constitution came into effect during the regime of President Jammeh. So obviously, he was not interested in reforming the law. So up to 2016, that was an impossibility. But think about this. You know, the 2016 election was won not because the people of the Gambia didn't like President Jammeh at the time. The president was an equal opportunity tyrant. So what happens? You don't care if somebody is your friend or your enemy. As convenience dictates to you, you punish people. So 2016, everybody, friend or foe, was in danger. So they don't want the government anymore. That was the only reason we were able to get rid of it. So, but the president today is telling us he was the one who killed the lion. So he can do whatever he likes with our laws. He can tilt them to his advantage. That, in the long run, would fail as well. It can, those kinds of conduct, as far as public life is concerned, cannot endure permanently. It would have to fail at some stage. This discussion is also germane because no challenge is more profound to national cohesion and survival of a nation than a constitution that serves only the interest of the fraction of the polity. In this case, the executive. So it is not us alone. Even those who are sponsoring us, scholars in other jurisdictions, really were looking at this. And they said, at the heart of any failed state is a constitution that is not performing, either because the balances its drafters struck between competing demands on the document were wrong, or because the mercenary will and resources to make it work are woefully inadequate. These existential points cannot be overemphasized. We have to create neutral documents that are not looking at the interest of particular individuals, especially those that are in authority today. More fundamentally, those who are leading the executive branch of the government, because that is where all this misbehavior comes from. As a national document, so the Constitution cannot accept that. It has to settle public power fairly between the different branches of government. And of course, not only the different branches, but between the different branches and the people. That is why we have the Chapter 4 provisions in the 1997 Constitution. Those are the fundamental freedoms. Those fundamental freedoms were not able to be amended because they are entrenched. So if you want to remove them, you have to go to the people and say, okay, we want to remove your freedom to express yourself. We want to remove your freedom to practice your religion. We want to remove your freedom your ability to access academic freedom. Obviously, nobody is going to vote for them. Now, the president would use raw power, bully the judiciary from time to time, and then they will clamp down on the fundamental freedoms. We call them the Chapter 4 freedoms in the 1997 Constitution. So, you know very well that you are not going to be able to change those, so nobody tried to change them because they are entrenched. The National Assembly and the President alone cannot do it, cannot change those provisions of the Constitution, cannot remove them. You have to do it through the cooperation of the public. That is, you have to go to a referendum. And like I said, such referendums would fail. If you say, we want to remove your freedoms, people will say, no, we're not going to vote for that. You cannot come after the whole country and punish everybody. And if you have weak institutions, because that was what my senior counsel here was saying, weak institutions is equal to bad government. Yes. So once you don't have good institutions, your governance would be bad and your country would be backward. There is no question about that. Accepting that a polity with weak institutions cannot ensure accountability under the best constitutions, there is nevertheless a compelling need to retreat from the brazen amalgamation of public power in one branch of government. And that branch of government, as stated earlier, is always the executive. That was responsible for the revolutions that took place in the United Kingdom. Those revolutions were responsible for the changes that took place in France in the 1900s. Those revolutions were the ones that also took place in the United States of America, culminating in the 1789 Constitution of the US. A small document that ensures that governments, presidents in particular, because it's always the executive, stay within the boundaries of their authority. And if you don't, you are taken to court, and the Supreme Court will rule. The Supreme Court, routinely invalidates legislation that conflicts with the Constitution, because that couldn't take place. Even where the call for a properly balanced Constitution is heeded, the recognition must nevertheless remain that no matter how beautifully crafted and appropriately balanced, law has no capacity for self-implementation. It relies on the responsiveness of a political system to the rule of law, both as abstract doctrine and a reliable instrument of practical governance. So again, scholars have been looking at these things. They said worldwide constitutional setups are in a state of flux. As states across Middle East, Africa, and Asia look for successor arrangements to dictatorship, minority rule or anarchy, the pressure on new constitution to provide a stability that can be hardwired into the foundations of the state are immense, because it is in the interest of the people to ensure that you have constitutions that are responsive to the needs of the people, to the survival of a country. If anarchy, not from you and I, but from a dictatorial government continues, it will collapse eventually by violence, and of course that is not to the interest of anybody, but ultimately it will collapse. That is just the nature of human affairs. So in the Gambia, the Constitution is devoid of serious beauty, due mainly to the apparent absence of any real intention to ground the polity in objectively verifiable rule of law. These may be attributable to the fact that the political midwives of the Constitution, those who would assist a woman give birth. So in this case, if you talk about that in the context of our Constitution, we are simply saying the political midwives was the government in power in 1996, 1997 that brought the Constitution to fruition. Yeah, they were interested. They had absolute power. They were interested, and they wielded the veto. So if you don't want it, it wouldn't be there. Not knowing that you are digging, your own destruction ultimately, because that is what will happen. Yes. So this failure to adhere to the rule of law really is not in the interest of, particularly of those who are in government. Yes. So what this means is that the 1997 Constitution is a document that has immense potential for violence, Yeah, if you want to be violent, you can really be violent using the law itself, the Constitution. A crisis, any crisis in governance, is therefore only solvable via the agency of raw power. So instead of adhering to the law, you use your power, you use your NIA, you use your police, you use your military, and then you threaten people and detain them unlawfully. Once you do that once, twice, 3 times, there is still an underground resistance. But really, a lot of people would be very careful. It's like the Mandinka proverb. Your mother, your father would probably tell you, why don't you leave this government to do what it wants? Yeah. So it does not work for anybody. Now we are talking about the draft constitution and the consolidation of the rule of law in the Gambia. Considering its length, this discussion makes no attempt to rewrite the constitution provision for provision. But now we are looking at why the rule of law is very, very important. Because if people are unable to breathe, they will eventually turn back on you, destroy your government, maybe in the process destroy the country as well. You cannot do the rebuilding. It will take years and years and years, and it will just consolidate the disdain of other countries around the world, especially the Western democracies. The non-black communities would say they can govern themselves. That is the way things are all across Africa. Is that a reality? Yes. You can discuss the nuances, but it is, as a general principle, that is a reality. So, consequently, the focus is on the basic ingredients that must go into a modern democratic constitution to pass the crucial test of separated power. Power has to be separated, otherwise there cannot be any rule of law. The demand of the separation of public power is premised on the need to ensure liberty of the person. This was what some of the key proponents of the American Federal Constitution in 1788, before the coming of the 1789 Constitution. America, of course, they debate everything. Yeah. So during those debates in the year to 1789, so that is 1788, some of the public intellectuals, the key public intellectuals of the era, and of course, these were James Madison. They wrote the Federalist Papers. They don't want a segmented America. They want an America that is a federalist state with a lot of power that can, because the era, obviously the colonial powers of Europe were still very active in the Americas, and America was a young republic at the time. So they need to protect themselves. So in the Federalist Papers, the likes of James Madison contended that the accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. Tyranny is dictatorship, controlling the public space as if it belongs to you, when in actual fact, that is not the case. So according to Madison, relying on Montesquieu, Montesquieu, of course, was a French politician himself, and philosopher. They said the separation of powers is the preservation of liberty, and it requires that the 3 great departments of power should be separate and distinct. The proposition that no society can begin to approach completeness in the absence of explicit rules which are understood by and applicable to all without distinction is unassailable. People need to know the law, and the law must be applicable to everybody, because without that, the country cannot go anywhere. People will be tired and they will rebel against your government, and that is not good for the public life. For those in this hall who remember 1981, the destruction in the Gambia was unbelievable. Yeah, and that was just over a period of 4 or 5 days. Yes. So I was working at Radio Gambia at the time, So when it happened, Radio Gambia was attacked. They said people like us were all killed. So obviously, you could imagine the relief when I went back to Gunjur, in one of the military trucks. When the conflict was even raging, the Senegalese soldiers were here. I guess I could have escaped Radio Gambia and then put myself in trouble by traveling from Sukuta to Gunjur in the dead of night with rains. Rain was all over the place during those July days, from the 28th all the way to the early August. The rains were ferocious. Yeah. So the proposition, so this is what we have to do. There is compelling truth to the contention that no society can meaningfully endure in a climate where lawlessness pervades the spirit of its public life. Lawlessness, in this case, from the government itself, because here our lawlessness is mainly from the governments. Yeah. As a concept, the rule of law is one of those political and governance principles whose ostensible embrace by dictators and Democrats alike makes it susceptible to perverse interpretation and the confusion naturally attendant to that abuse. Senior Counsel, His Lordship, said that here before. So you can say, I am a democratic country when you are a totalitarian country, like Soviet Union was a totalitarian country before the collapse of the Soviet Empire in 1991. It was a totalitarian country. So it cannot compete with the United States at the time. Just look at the development between the two societies. The people in one country are free and developed with economic benefits for everybody. The people in the other country are the direct opposite. People struggle for their food, but those in political authority could afford everything. Big yachts, major houses at the expense of the state. So when we say, let us try and promote the rule of law, don't say no. The government I support is in power. Governments are temporary. They come and go. The country, the Republic of the Gambia, remains. So nobody should support anybody because you belong to that party. Parties don't govern, people govern. If you want good governance, you have to distinguish between those available to you. Yes, and go ahead and empower those people. So now you ask yourself the question, with all these challenges we had with the 1997 Constitution, why is it so impossible for us to have a replacement Constitution that, of course, would be amenable to the democratic dictates of our country? Say, for example, the draft constitutions that we are told to talk about. 2 attempts were made. 2020, the drafts were inadequate. 2020 was inadequate in several areas, but it could have been negotiated. Yes, the Constitutional Review Commission was of the view that what it presented has to be accepted as a whole or rejected as a whole. That is not the position of the law. The National Assembly has the ability to look at legislation and decide what to do with it. So it can look at that legislation and do amendments. All we needed were amendments for the National Assembly to pass the 2020 draft. Now, if you look at the 2020 draft, say, for example, it says that the president's term should start in 2017, when he first came to office. Obviously, that would be retroactive. If the country agrees to it, it could happen. But if it is contentious, even if it goes to the Supreme Court would not agree to that. It was not tested. So we don't know what the Supreme Court would have done. But that was not necessary, because the politics, it collapsed in the National Assembly, because the politicians couldn't negotiate. They couldn't trust each other. So it collapsed in 2026. But that retroactive clause was one of the key reasons. Yes, the president believed that it shouldn't apply to him, because the thing was not even law at the time. And that is, there is a valid argument in that, because the 2020 draft itself says that it comes into effect after the referendum, a day after the referendum. So this thing is making the rounds politically. It didn't even pass the National Assembly. And you want to apply it to the president, who came to office in 2017. You want to say that that law should become effective in 2017. When in January of 2017, of course, was it the 19th or the 21st, the President Adama Barrow commenced his first term. You cannot apply that to him, regardless of, except if Adama Barrow and the political establishment at the time agreed to that. But otherwise, there is compelling legal argument that it wouldn't make any sense, because the Constitution itself says it comes into effect the day after it was passed in a referendum by the people. So if that is the case, how could you apply it to the president? So that was one of the main reasons why it failed. I also oppose it. Obviously, I was one of the key people to oppose it, because a good chunk of the Constitution was copied from the 2010 Constitution of Kenya. I was unhappy about that as a sovereign country. I didn't think that should have happened after such huge amounts of money were allocated to the Constitutional Review Commission, after they even had the opportunity to travel outside the Gambia at the expense of the people. Why should they not be able? You can study some of these things, because if you look at the fundamental freedoms, they all go back to the, say, the American Revolution, the French Revolution, the governments that, the constitutions that came out of those. But more fundamentally, to the Universal Declaration of Human Rights, you know, the precursor instruments that were responsible for the UN Charter. Yeah. So obviously, the fundamental freedoms, we could cooperate on that in those things, because the understanding is the same. The European Convention on Human Rights is the same, is very close to the Universal Declaration of Human Rights. It's very close to what the Americans call the Bill of Rights, that is the first 10 amendments to the American Constitution. So they came into effect at the same time with the American Constitution. And they became the bedrock of freedom for the people of the United States against these overpowerful executive governments. So yes, we could copy each other when we are dealing with those. But Gambia's condition is not exactly the same as Kenya's condition, except for the fundamental freedoms. Yes. So I was also opposed to the fact that the judges, you know, a judge would get, say, right now about $150,000 per month as pension. Now, a teacher, even our eminent doctor here, yes, maybe from when he worked for the ITC, the International Tripreneur Tolerance Center. When he worked there, that was an international appointment, so that has nothing to do with Gambia. Yes, but otherwise, his pension would have paled into insignificance with the monthly pension of a judge. I thought that was very unfair. So I opposed the Constitution 2020 on that basis as well. And, you know, I didn't go to radios alone. I wrote extensively on them. I believe that those who work for the public sector should have the opportunity to retire on a decent pension. So that was one of the other reasons that I oppose it. Yes, but coming to the 2024 draft, yes, what the government did was wrong. It did not consult on the draft. When the 2020 failed, instead of political collaboration, they did not collaborate. And they just went behind bars, you know, and came up with the 2024 draft. That's why people call it the Barrow draft. Yes, so it was opposed. We knew it would fail in the National Assembly because the UDP leader said even if a dot is removed from the 2020 draft, the UDP would oppose it. So with that threat, it had no chance of survival. But again, it was a lack of political will. Seeing what we went through all the way to 2016, obviously a new constitution for the Gambia should not have been a problem. The political deadlock was a matter of great concern. It was failure at the level of the politics in the Gambia, whether that politics is within political parties or the members of those political parties within the National Assembly. But once a political party did not support it, and it has significant representation in the National Assembly, there was no chance for them. So this is what we are still dealing with. Now we are confronted with an entrenched government. An entrenched government, we're going to elections with an entrenched government, and he can win just by one vote. If he has, say, 10 votes, the other parties have 8 or 9 votes, it doesn't matter. Their votes together are more than his, but he's first past the post, so he will win. Yeah. So some people are of the view that it's better to compromise on that, so that later on you'll have an opportunity to look at those anomalies and ratify them. You know, but obviously there was dispute about that as far as the politics was concerned. So for me here, the key message is not whether the 2020 or the 2024 failed. The key message should be we should try to control our political leaders, not those in government, but even those in opposition. Yes, we must not do their bidding all the time. We cannot support them blindly. Nobody feeds your family, you feed your own family. So you must not be blind to those realities to the extent that you endorse everything that comes from your party. So at the end of the day, this is what we have to do. We are now almost at the tail end of 2025. If there is political commitment, yes, by March, April of next year, we should have a new constitution. Yes. March, April, yes, we should have a new constitution if there is political will there, because there are entrenched provisions, not only general provisions, entrenched provisions. So for that to materialize, if you want to change the constitution, you are going to have to go over a 6-month period, minimum 6 months, because there'll be the logistics within the National Assembly, the announcements and the Gazette and things like that, the votes, the referendum. So that can take all the way to between 6 and 9 months. It's a very tight window, but if there is political will, it can be done. Yes, we can harmonize all the one constitution, the 1997 current constitution, and the 2 drafts. They can be harmonized. Yes, we know how that should be done. We can do that. Remove the anti-democratic provisions out of the Constitution and the two drafts and get something that we can work with as a people. Yeah. So this is what my own, because we can go into the details, but there is not much difference really between the 2020 draft and the 2024 draft. Minor differences that shouldn't collapse a political dialogue if there is will for that dialogue. So that's the takeaway for you. I don't know whether you have school newspapers or university newspapers. You have magazines that you can drum support in, against the government, against political parties, and say, look, let's come together. This is what is in the best interest of the country, and move this country forward. Yeah, we can do that, but we have to have the political will. It is absolutely necessary. But this is the problem, is where we are today. We are trapped because of political impasse between the different players within the National Assembly. Yeah, the political impasse there, the payback time, if you like. Some people are saying, okay, the government collapsed the 2020 draft. We are going to collapse the 2024 draft. But I think between the two of them, a compromise can be worked out, and we can go into the 2026 elections knowing full well that no single person is going to be allowed to destroy our country. We can't allow the leaders to do it. Yeah, and so before it becomes law, we have to go through the political process. And that is where the difficulty is. But I believe, the politicians can work it out. They can work it out. They can come to a kind of a compromise. Take the most controversial provisions out and then deal with the text. Once you are able to agree the text, you can do the amendments. You can do the amendments over time. You can do the amendments over time. So that's where we are. So you want us to talk about the drafts. That is the fate of the drafts. Nobody can do anything about it other than the president in collaboration with the opposition. Yeah, the president was wrong to go behind the scenes without consultation to bring the 2024 draft out. That one is not necessary. So the government is entirely responsible for the failure of the 2024 draft. Even though from within the public, there was sizable support for the 2024 draft, But even if there is not, we can harmonize these three. That is possible. Rush it through the National Assembly, the people will vote for it, and then we have something that we can work with. But right now, it's an advantage for the incumbent president. The provisions in the Constitution, the president famously said, he has the laws that Jammeh had. He had the military, he had the police, and, So obviously, that is it. And you have the Constitution. The Constitution, obviously, is not, 1997 Constitution, is not something we should go with to 2026 if it can be avoided. But of course, it's a tall order. It's very, very difficult. Actualizing it would be a Herculean task. So politicians would want to, they would have to negotiate. Unless you are able to negotiate those things, there is absolutely no way we can get a new constitution. And it's the same. I believe we can. This is a whole country. In fact, some people said, let's edit the 1997 one. We didn't even need the 2020 or the 2024. Editing the 1997 would do it. I believe it could do it. People like Khalifa Saleh propounded that possibility. But of course, people didn't take it seriously. We think anything coming from Yahya Jammeh, of course, is poisonous. That is not the case. 1997 could have been edited. Yeah, we could take the anti-democratic provisions from out of the Constitution and move the country forward. So the challenge is your leaders. If you don't want the 1997, you have to persuade the political leadership of the government and the opposition to compromise and give us a constitution that would get the support of the general public. Thank you very much. I'm grateful.
Traveling has never been this simple in the Gambia. Oh yes, you don't need to visit the GTSC depot just to get a ticket. Just download the Yona Wallet app today and enjoy hassle-free bookings. With Yona Wallet, you can buy your GTSC bus ticket right from your phone, anytime, anywhere. From Kanifing to Dakar, Dakar to Banjul, or up-country routes like Kanifing to Basse and Basse to Banjul, Yona Wallet has you covered. No queues, no stress. Just safe, fast, and convenient ticketing at your fingertips. Choose comfort. Choose convenience. Choose GTSC with Yona Wallet. Yona Wallet. Your money, your way. GTSC. Moving the nation forward. For more information, please call 1124 or 221-1668.
Mansarun kilinye, birika masum